I know that it is very trying times for all of us. I mean, I'm sure this morning when we woke up, we had some second thought as to whether or not one, the committee will be meeting or whether or not you should appear. Yeah, yes, yes, but committed we are to the task ahead of us, and I want to commend you for um, presenting yourself here today on the understanding that we all recognize that there is great and enormous task ahead of us. So I want to thank you, members, for making yourself available to proceed with our meeting as per usual. Um, Before Senator Gill comes in, I want to recognize that we have before us certain um, documents that have been provided, served on us by the ministry, 2 documents from the ministry, in keeping with our labeling. I don't know where we are in our labeling for these documents that we get from the ministry. Senator Gill, you perhaps will assist us at a certain point, or clerk. There's also a summary sheet on decisions made by the committee, 1 to 118. There is a response from the JDF in respect of the last letter we sent to them, which was dated on February 24th of this year. Members, do we all have copies of these documents?
Documents so that looks like they have never left a file for a very long time.
Well, yes. Yes. Now, in respect of the documents from JDF, we will look at these documents at a later date, as is convenient. What was the verbal communication? What did they say?
In terms of the JDF?
Yes.
Well, they answered the part about the standing orders in terms of the establishment and the employment status of the civilians. We will get that communication from the ministry.
Okay, fine. So I have been advised that what we have been provided here with is a part of the response. In respect of the standing orders that we had requested, they have provided us. In terms of the staff orders,
Employment status of civilians.
Employment status of civilians, I have been advised that that reply will come through the ministry. Through the Ministry of National Security. So we have the staff orders or standing orders here, but in respect of the employment of civilian workers and in respect of the establishment, that will come through the Ministry of National Security. We have not had any response from the Constabulary Force, JCF, and contact will be made with them. So we will defer this for.
Contact will be made with them again.
Again, that is so.
Okay.
That is so. So we will just hold on to this until we have gotten the other part of the response and also to see if we will hear something from the Constabulary Force.
I'm suggesting, Chair, that we just wait until we would have received those set of responses from the Constabulary Force to have one discussion around the national security issues.
I share that view too, Member Gill, and I believe the committee is in agreement. So we will defer until we have the comprehensive response, and we will just deal with it as they come in, when they all are in, that is. So we will proceed. The intention, members, is to proceed with the continuation of our clause-by-clause analysis, and we are set to pick up from Part 8. So the Ministry of Labor would have provided these documents. When were they sent? The documents, when were they issued? Yesterday?
Yesterday and this morning.
Okay, fine. I recognize that these documents came a bit late, but the ministry is here, and they will take us through the documents in considering Part 8, which we are now proceeding to, which begins at, is it section? Section 132. Members, any other, before we get into the clause-by-clause consideration, anything that you want to put before the committee? I take that as a no. So, Ministry, I am now turning over to you.
Good morning. The bill, Part 8, deals with administration of safety and health. It's an important part of the bill. Currently, under Clause 132, the bill is to be administered by a Department of Occupational Safety and Health within the Ministry of Labor and Social Security, plus the Department of Occupational Safety and Health. And a lot of the functions will be carried out by the Director of Occupational Safety and Health, who is a public servant employed to the ministry, and occupational safety and health officers. We reviewed many concerns raised. We reviewed concerns raised because the director is a public servant employed to the ministry and was being given wide remit in this legislation. And concerns were raised about the constitutionality of the provisions and the role of the director. And it also has an impact on other clauses in the bill. So, bearing in mind all the concerns raised, we had a second look at the matter. And we came to the conclusion that we needed to have a body corporate to actually carry out the wide remit of this bill, bearing in mind that the bill actually binds the crown. And you needed some amount of independence of this body. And we wouldn't want to have a one-person director carrying all this remit. We prefer to work with an authority, or whatever the name is, that's the name we have for now, a body corporate, that will be able to carry out the full functions of this bill. So what we have come before you today is to communicate a policy change in relation to how this bill would be administered by the establishment of a body corporate to carry out the functions. So I will revert to the policy document. Now we would have to be guided by the drafters. We have just set out the policy, but there's a certain way in which you draft provisions in relation to body corporates. So going to, I don't know if we had named the documents, but the first document, policy in respect of establishment of body corporate under OSH bill, dated March 11, 2020. So I will start. Under the authority, number 1, the Occupational Safety and Health Authority should be established. This authority is a body corporate to which Section 28 of the Interpretation Act applies. So this would have to be an amendment.
So the first amendment is an amendment to the part itself.
Well, at this point, I'm
Yes.
communicating the policy because the drafter has a certain way in which they introduce positions re body corporates into the law and where they actually do it.
Okay. Mrs. Hildebrow, you wanted? Yes.
I'm going to wait until she's completed the presentation, then I will respond.
Okay.
Yes.
Very well.
Chairman,
Yes.
this policy change, could we get a little about the process of the policy change, including, my sister says, rationale for it, and I want to get a sense, as Cabinet signed off on this policy change, or this is a policy change from the ministry. Let me tell you why. There is a view that we need to be moving away from all of these.
The cabinet has approved this. So I can,
The Cabinet has approved
Yes,
one
sir.
more statutory body to add to the 160 odd that the minister declared we have coming down from 190 odd. And so I understand that. And this would now mean that we're approving a new set of workers, a new establishment. I want to get a sense of what the size of this establishment. Is it different? Is it that we're just taking it from just the Ministry of Labor and having it separate? Or because now we lose all of the labor officers' connection because this is separate. So I want to get a sense of what led to that and so forth before I.
Okay. Mr. Benny-Campbell.
Yes, as I said, we looked at it because this act, in order for you to properly enforce this legislation, and because it binds the crown, you needed a body that would have more teeth statutorily and some more independence from a ministry. So that was one of the reasons. We recognized the director could not stand in these provisions. We would have had to change the director to the Ministry of Labor and Social Security. So the options to us would have been to administer through the ministry, although the act binds the crown, or through a separate entity, which is a body corporate. Because the provisions right now could not stand with the director, public servant, having this role under this legislation. We looked at concerns because quite a few of the stakeholders had raised the question about one person having all this power under legislation for all this enforcement, all these functions. And so we also considered that concern was a valid concern. When we look at it, occupational safety and health is important. You really need an authority or a body that is focused on full compliance with this law and enforcement of the provisions of this law, and to be able to properly carry out its remit. So we also took that into consideration. We did not believe the current structure would lead us to be effectively able to carry out the functions of this legislation. And so, having been before the committee, and we have been asked to look at things practically, we looked at things practically, and we saw that what we had, we did not believe was the best approach to this legislation in terms of the administration of same.
Yes. No, Member Gill, before you, I recognize Member Brownberg. Yes.
Thank you very much, Mr. Chairman. I am actually very pleased to hear the response and perspective. But I'm just wondering, how did it catch us by surprise? How is it that today we wake up with this revelation?
Well, we honestly were seeking not to create another public body. That was the first approach, because there's a trend towards rationalizing these public bodies. So we were trying to work within a format that could be workable without creating a public body. But the more we proceeded and our thinking, we started changing our minds from the stakeholders consultation started in terms of, is this the best way to approach this? And we took it into consideration. It is a hard decision, but we are here to make a bill, a legislation that is workable. So we took the hard decision that we had to reconsider this matter, despite the fact that it would raise these challenges and these questions. But if we have been looking at a way to make this bill workable the whole time, then we could not ignore the fact that we saw that we are having a problem, and it's not going to disappear. So we are trying to fix it.
Yes, Member Gill.
Chairman, sequence of events are important. And I hear about a stakeholders consultation. And when the legislation was put before us, we would have had our own concerns in terms of the awesome responsibility that would have been imposed on a director. And for that director to be able to effectively and fairly and reasonably carry out the objectives on the mandate. I have to be clear in my mind as to essentially what part of these consultations, including this particular engagement that we are having here, would trigger this dramatic but important shift. That's the first thing. The second thing is that you're now setting up or proposing as part of a policy shift to establish an authority. And that authority, I assume, would have its own regulations and a possible legislation to bring it into effect. No, let's understand something. Because is it a separate set of regulations or legislations to instruct the operation of the authority, or will it be aligned to this piece of legislation? And are we going to be privy as part of a joint select committee to those tenets that is going to guide that authority? Because I would want to leave these discussions in clearly understanding what those guidelines are going to be and where would they fit in line with what we have been reviewing as part of a legislation. So now that it has come upon us, and it's important, it's a gigantic shift, but one that is very, very important to carry out the effective functioning of this piece of legislation. But I just want to satisfy myself, Chair, that I would become aware of that. And then again, I know the work that has been put in place by the various legal team, but this is going to call on additional work to be done. So those are my initial concerns.
Mr. Chair.
Yes,
I heard Senator Gay says the body is important, but I'm still not clear as to why the shift. We spoke about consultation, and it's a bit unfortunate that we draft the bill, then we say we consult, and then based on the consultation, that we're seeking to make amendments. I understand, but I'm not clear as to why the policy shift. I heard we want to give the authority some independence. Independence from what? The ministry? Because ultimately, who are they accountable to then? It's a public body, so I don't know what I want to greater clarity as what type of independence we want to give it. And so therefore, who will monitor your work? Who will they report to ensure that the objectives are being met? So I want a greater clarity on that word independence. But I'm still not clear as to the policy shift. And is it that all issues of safety now will be under this authority? And so we're talking about labor officer, which we need to make a final decision on. if we're going to give them this general role, let's say we agree on that, but then how would they fit in with this authority, having safety responsibility while still working with the minister? So I think there are still general areas, and I want to be more convinced as to the rationale for the shift and how the body, because what we're really asking for is to create a new bureaucracy, and sometime in the public sector we create these public bodies hoping for efficiency, and we end up having the reverse and not achieving the objective.
Very well. Minister?
When I spoke about the stakeholders, I was talking about the stakeholders who would have appeared before this committee. Yes, starting from that's what I'm talking about. We looked at the feedback of the stakeholders that everybody has been questioning this director. So that's what I was talking about. It was this process and the stakeholder feedback that we would have received here. Relation to the director, as I was saying, the director is a public servant employed to the Ministry of Labor and Social Security. This ministry would, of course, be also bound by this legislation. This legislation will apply to all workplaces. So we thought about it, and as we said, we thought a body corporate would have more room for some amount of independence. Yes, it would still be responsible to a minister, but not in the same way as the public servant within the Ministry of Labor. That was one of the things raised. In relation to how we would address it, those provisions in relation to the body would have to be included in this particular bill. And the functions and the roles of this body would have to be in this bill. This bill would have to be amended to make room for what we are doing. So it could not be a separate document. It would have to be in this bill.
Mr. Chairman,
Yes.
I certainly appreciate the questions asked by Senator Skeffrey and the response given. But when I glanced at the Board of Management and I looked at the appointment, all of them, the Board of Management consists of no less than 8 and no more than 12 members who are to be appointed by the minister. I don't know if I missed anything down the bottom. It says from where, but you know there's always that issue about exactly how persons are appointed. When you say from the manufacturing sector, does that mean that it is the manufacturing sector who makes the recommendation? Do they recommend an individual who is to be appointed? If you understand what I'm saying, because this is going to be enacted and applied, executed in a real world. And so we have to bring to bear how we know things actually operate. So I didn't see the clarity that I needed in terms of how they are to be appointed from these various sectors and the role of the minister, either in vetoing or I can't find another word that would be balanced. So I just want to say it like that. And then I also know that they hold office for no more than 3 years as well. And as we know, if there is no certainty of tenure there, the independence that we seek by establishing this board could very well be one in name only. Yeah? And I also know that 13 that the minister is to be given the authority to appoint any person to act temporarily in the place of any member of the board. So what I'm really seeking is that if we are seeking that kind of independence, then I think it has to be built in from day one. And I must say that I'm not seeing it.
Member Brownberg, I'll just take you back to point 10. Is it that, because I listened and I am still trying to understand what you're putting forward. Is it that you're saying there's no specific reference in the language here to suggest that there would be consultation on the part of the minister with the manufacturing sector or the agricultural sector. Is that what you're saying?
Well, there certainly is no language to suggest a consultation,
Okay.
but quite frankly, I wasn't expecting a consultation in that regard.
Okay.
If they are to represent the manufacturing sector or the agricultural sector, at the very least, I would expect some kind of overarching body to make that recommendation, if you understand what I'm saying. As it is here, it could very well be that the minister identifies a friend who could represent the manufacturing sector or the agricultural sector. And I'm just saying that if we are in fact looking for the independence of the board, that those are issues to consider. We already have representatives from the Ministry of Labor and Finance and other areas where you would understand the minister's influence, but certainly from those two, I'm just saying that it would need to be more specific to really reflect what we have said is the aim of establishing it in this way.
Chairman, I want to direct the ministry to bodies or boards that would have been developed through the Ministry of Labor. And the approach that is always taken is one of a tripartism approach. The Productivity Center would have established one such body. And in this case, when I look at the composition of the representatives, I am not seeing in this board anyone that resembles the representation of the worker. I am not seeing that. It may have been an oversight. It may have been a diversion. No, I have no intention of leaving these shores.
These warm and salubrious shores.
But if it's not an oversight on the part of the ministry, then it's a glaring concern in my mind. Because critical to the fulfillment of this piece of legislation is how we protect the workers. And we can't leave it up to the employer groupings and the Ministry of Labor on its own. And any expert to represent the concerns of the workers in this case. So I want the ministry to again, it may have been an oversight. It may mean that it's not 12, but 13 members. But I want the ministry to include a representative of the worker.
Yes.
I asked a question earlier,
Yes, Member Brown.
and I knew that the answer to that question was going to come up subsequent. I asked, did this proposal to move to authority had the support of the cabinet? And the answer was yes. So unlike my diplomatic colleague, Senator Gale, I can't accept that it's an oversight. I want to know how could it be that the cabinet of this country advancing occupational safety and health bill and an authority under it.
Yeah, but Member Brown.
No, let me finish, please,
yes,
Chairman.
Yes, because I
Not
think,
have
I think-
anybody in it from the trade union movement. And it's just unacceptable, and it reflects a philosophy which doesn't recognize and support the critical role that the trade unions, the guardians of democracy, the protector of the rights of the workers, have played through Bustamante, through Hugh Shearer, through Michael Manley, through Upton Cable, and through the plethora of trade union leaders. No, we are just in the movement.
but Member Brown,
Right, so, yeah, yes.
the specific question was in relation to this body corporate. The composition of the board is under paragraph 10, which member Brown and member Gale commented on. It is what is before us, and I'm sure the recommendation of member Gale and how it has been presented has not gone unnoticed. But in respect of what the cabinet approved was that shifting policy to the establishment of the body corporate. Yes, not the composition. Yes.
Chairman to be saying that the composition of the board of management hasn't gone to cabinet.
What I'm saying,
and that you are open by the time it gets to cabinet.
yes.
The relevant ministers who must comment would have picked up the omissions of the trade union that the Ministry of Labour itself had not picked up.
This is why we are here. The work of the committee includes that.
Chairman, I don't think you understand.
Yes.
The point I'm making is that the Ministry of Labour cannot conceptualize a board on a matter like this and omit the trade unions. And I've been complaining throughout this bill.
There is no deliberate omission, Member Brown.
Whether it's deliberate or otherwise,
yes,
it's
so the point that I know you did say, Member Brown, that Member Gale was being sophisticated, but deliberate.
He is always sophisticated, but in this one, he's just being diplomatic.
I believe the submission of Member Gale has not gone unnoticed. No, I think Member Gale spoke for Member Brown when he did speak. Yes.
Chairman.
For the collective.
No, Chairman, just let me get it. Because sometimes our philosophical underpinning guide our decision. And if the Ministry of Labour who comes up with this sends this...
Member Brown. You see? Member Brown, let us proceed. The point.
No.
Member Gale has spoken.
No. I wish to put on record, I've complained constantly throughout this bill that the trade unions are not part of the thinking. And it shows up again. And I want to get this Ministry of Labour to understand that in the scope of work, labor is an important part. Today, the people up north is talking about leave for workers who get sick. We passed that long ago. So much I want to commend your ministry for saying the 14 days or the 2 weeks is a minimum. Employers in the current situation can give more than that. And I do this conscious of a podcast that is to take place from some lawyer who says he's going to explain the rights and responsibility under this. And I'm sure he's going to say the rights are limited to the legislation. No, not Malcolm. Another one from down the road there. Right? So that he's going to be saying the law says 2 weeks and you'll be in your right to do it. I don't know that he's going to be saying the 2 weeks is a minimum and that some company now, as Senator Gale and I are aware, give more than 2 weeks if people get injured. So I want the ministry officials to get in their head that anything about work must involve trade union. And so TEN must find its way, and I don't take it as a mere oversight. I think it comes from a philosophy which says we really don't need the unions in this.
Member Brown, I understand your passion, but again, I will say that Member Gale's point has not gone unnoticed, and I took it to mean that he was speaking for the collective. I don't know if that is what Member Brown was doing.
Mr.
Yes.
Mr. Chair. Oh.
Yes.
On a point of order, Mr. Chairman, I do not, in as much as many of us might agree with a point being made by another member, and certainly Member Gale would have the full respect of every member here, I do not believe that Member Gale has been delegated the authority to speak on behalf of the collective or any other member.
Nobody's. No, that's... Yes, Member Gale. Nobody is saying that, Member Brown, but the context in which the comment was made, and for having heard from Member Brown what he's saying, it is important for me to put out there that the even from where I sit, I see merit in the submission that was put forward by a member. Yes. Yes. But,
Mr. Chair, another
yes.
point on the same board of management. I just want to, am I right to interpret that appointed by the minister means will be named by the minister? So am I right to interpret that? And that's where we have a problem. If we're talking about independence, an issue of safety and health, and we're talking about independence, how can we have the minister naming / appointing all the members? Certain bodies must have the exclusive right to name them their rep, and it cannot be vetoed by a minister. In this context, we were talking about workers in the public sector, for example, and there are issues that come to this board that will affect the government, whichever party in power, government of Jamaica, and it might embarrass the government. Then a minister could shut down the board. Because a minister has the power to hire and to fire. So certain, no, we can't say no, you know. If a minister appoints me, he can withdraw my appointment at any time to a board. But if there are certain clauses that say certain institutions must have, and certain, but it can't be that every single member. So if you're going to put in the trade union, is the minister going to determine who represents the trade union? Can't be.
Yes.
No, I'm just saying that could never be.
Member Skeffrey, I'm just...
Mr. Chair, hold on, Mr. Chair. Let them make the point first. Because I put my question in context, you know. I said, am I right to interpret? And the ministry said yes.
Precisely.
And so if they said no, then I would have said okay. But if it's the minister, who's there by the minister? And in context and about personality, because some person will act honorable and some will not. But laws must not be made on that premise. So if a minister gonna have a safety board and health board, and the minister has exclusive right to appoint or name all members, then I have a fundamental problem with that.
Yes, Member Gill. Member Campbell.
What other construct that would Member Skeffrey put in place?
Yes. Well, I'm going to ask the AGC to come
I can
in.
tell him. I know of so many bills I've seen, and the AG chairman can guide us, that you say that this body, for example, has the right to name. I gave an example. Let's say we're going to include the trade union. It can't be the minister. So if you say a rep so named by the Confederation,
yes,
or a rep so named by the manufacturing sector, so they name their rep. Minister can do the formal appointment, but as was said by the minister.
But that is how I understand it.
I asked the question.
That's how I understand it.
Here.
Yes.
I was deliberate when I asked my question. You know. No, I asked, am I right to interpret that
and you
appointment?
got a response?
No,
Did you get a response?
Hold on, man. Calm. We know we're nervous and panic, but calm.
No, I don't.
I asked a question before I made my point. You know. I said, am I right to interpret that appointment means the minister will name all? And I was told yes.
Yes. Because, and I asked the question because because my understanding is certainly that the minister would embark on a process of consultation. And once a recommendation is made, then that is when it is named. But
we can solve all of this now by saying who are to be appointed by the minister on the recommendation of.
Right. So it was a matter of language.
No, he's right. It's a matter of language. And if the language is not there, then it gets us into problem. So if we want to express ourselves that it's going to be a situation where the minister makes the appointment on the recommendation of, then let's state it, because it makes it precise and it remove the unclarity, the confusion, the mistrust. Because as we're saying, this is a bill that is need buying. May I also, Minister, recommend that of the 12, that a body representing professionals in occupational health and safety should also.
And point number 6, Member Brown would not satisfy that?
With knowledge, experience. That could have been, that could have been somebody in Canada. You understand me? I want it to be specific to these people who have an association, who are working in the field, so that we could get their hands-on experience as part of the knowledge of that committee. And also, well, I was spoken about the training. And I don't see here an association like the Bar Association, the bar, even them put him. But no, until you decide who they put. But again, they would have a lot of experience in litigation that may have arisen from this bill, so it could guide the committee. In other words, we're trying to get the best fit we can, and in so doing, reduce the discretion of one person.
Member Gill.
Today is Thursday. On a Friday, I never normally agree with Member Brown. But the question of the appointment is critical, and in this case, it ought not to be left up to a minister to determine. Because one of the things you want to ensure in the composition of this body is that you don't have square pegs in round holes. Right. And you have the skill sets that are required. And normally, take the trade unions for instance. You wouldn't want the minister to determine who that representative ought to be, but for the trade union to identify among itself who that person ought to be given the requisite skill set. And there has to be, in 6, that person with the knowledge, experience, and qualification is really a singular person, you know. But you really want someone, chair, from a body who is constant and would represent the concerns of that particular body, and not just an individual with a skill set that you might take from academia. Right? So we have to be very clear in the construct, but that's why we are here in a ministry. We are here as a joint select committee to assist your policy direction and to identify where there may be gaps, that it is at this time we identify the gaps and seek to fill them, and we'd hope that you can take it on. But again, Chair, you know, I was going to make a response earlier, and Senator Brown said I must leave the mic alone. But in terms of a principle, no, in terms of a principle, there are certain objectives in relation to workers. That any time you have a platform treating with worker issues, it must involve, as a point of principle, that body that represents workers. And that is how we would have constructed all the worker-related legislations that we have now. They were never absent and were never deficient without worker representatives. And that principal approach must be continued to be observed.
That's a must.
Very well. AGC, in terms of because you have heard the members, in terms of other boards, because we have legislation, some in recent time, would speak about the establishment of a body corporate and deals with a schedule that deals with a board of management per se. I don't know if you have any comment in terms of what the ministry is putting forward here and whether it is in keeping with other legislations that may have been passed in recent times.
Thank you, Chairman. So I notice you're saying legislation in recent times because, in fact, I had just had a discussion with my colleague from Legal Reform Department, and we were talking about the fact that the older laws would have always just given all this power to the minister to appoint. Of course, in many boards you will have, and I'm just going to use sort of loose terminology, those that you may consider selected and those that you may consider nominated. And so the selected ones would have been, say, some ex officio, some specific posts. And then the nominated generally used to come from the minister. But in more recent times, that has changed. And especially with boards that are dealing with trying to get involvement from a wide cross-section of society, it's not usually just really left to the minister. So normally you do have a number of examples where, so in this situation where you say the manufacturing sector, perhaps it could have been the JMA that would nominate someone, nominate a rep, and then that person would be appointed by the minister. And generally, the law doesn't usually give the minister any discretion whether or not to accept or reject that nomination. And also, if there is a resignation, normally you would say that whoever has resigned, it would have been the person, whoever had nominated that person would be the one to then to make that new nomination again to the minister, for the minister to make the appointment. I also noticed the constructs. I realized that even though you only have, well, it says no less than 8 and no more than 12. It appears then that what would happen from this listing is that you would have to have more than likely would have to have had more than one person from a category. And the issue there would be, why would you select, say, 2 from a specific category and only 1 from another category? So I think those are things that you would have to, because you don't want anybody to think that one category is more important than another one. So these are little things that you'd have to think about when you're building out your numbers. But I usually suggest that we don't necessarily think of numbers first. You think of who you really need to be represented on the board. Granted, I would also suggest you don't want it too large, because if it's too large, you probably won't get a lot of work done. And so those are a few considerations that you could have. I do support, I do support understanding the nature of this board and what they should be doing. I do support the proposal that there should be a representative from a trade union. I also support the proposal that there should be someone with legal experience or legal knowledge. Well, really, an attorney at law. And I would suggest you also put an attorney at law practicing for a certain number of years on it as well, because there can be guidance that can be given from both those categories.
Mr. Chairman.
Yes, ma'am.
Sorry, and I apologize. One last thing. You could consider putting in something about gender balance.
Mr. Chairman, only because so much was made of it earlier, and in being polite or otherwise, there was a notion that it might have been an oversight. Item 13 under that Board of Management makes it very, very clear that the question asked by Member Skeffrey is absolutely appropriate and needed, and that in fact his understanding that the answer given implied that it was indeed the minister who was to appoint, even without reference. Because 13 says that the minister is to be given the authority to appoint any person to act temporarily in the place of any member of the board in the case of the absence or inability to act of such a member. Yeah.
Yes, Mrs. Seeley Brown.
I didn't want to speak to the specifics until we dealt with my issues, but in this case, remember, this provision is standard, which just simply means that even if you have persons who are appointed based on the representation of a group or a body, when there is a temporary appointment to be made, even though it is understood that the minister would then consult with these organizations who may have who may have recommended appointments, this provision doesn't in any way take away from the fact that once those provisions are in the bill, that the minister is to still consult, because you'll have to appoint the member based on the category in relation to the vacancy. So this provision, once we clear up and establish how the board is to be appointed, as based on what the SG has said, this provision is fine. So I don't want us to get too much into the language. I don't think they intended this to be drafting language when they made the proposal, but like we speak about the appointment and stuff, but let us not get too much into how it is written here without more.
Okay, well, thank you for that.
Yes.
I actually thought it was, but I should have seen that from others. Ahead of that, it was actually part of the drafted language, which sometimes we have that problem, whether it is drafted language or not. I just wanted to make the clarification, and I accept everything that you have said, and thank you for that clarification. But we have seen in not too distant past that what we expected from ministers is not necessarily what we get from ministers in terms of their behavior. So, I mean, forgive me for living in the reality that I am.
Chairman. Go ahead. Chairman?
Yes, Member Brown.
Yeah, I am understanding from the representative of the Office of Parliamentary Counsel, Mrs. Seeley Brown, that she understands these notes, that the bill must be drafted in the way she just explained it. And if that is so, then I hope we can record that as a decision of the committee that the bill intends, one, that these people are going to be nominated and recommended to the minister to be appointed, and also that it is implied that if a member from the manufacturing sector resigns or is not available, then the replacement would come
Through the same channel.
Yeah.
and if that's our understanding, I think we should record that as a decision
Yes.
of the committee, so we can then move on.
Yes.
All of us being adi them. And I don't know. Unless the ministry feels differently, then I think that's sufficient for us, Chairman, to accept that and move on.
Chair, just permit me to just make an observation.
Yes.
Because at this point we're talking about, when I look at 15, 15 speaks to the resignation of a member and the actions to be taken upon the submission of such resignation. And I take note that there are legislations that captures this particular part of an action in terms of separation.
Jack Croft, for example, did.
But
And some others.
the replacement is important, and the timely action of that replacement is critical, especially against the background that the construct of the board is so defined in terms of the skill set and personals and where they are coming from. So there can't be any gap in terms of an absence of that representative for too long. And I believe, and this is where the drafters can guide now, where if you have a construct that deals with resignation, you must have an additional trigger that treats with the replacement accordingly, and not to have this gap out there where the absence of such a representative, because it's going to be determined on if and when the minister decides to make the appointment. and a time frame.
Um,
Yeah, time frame, but also a trigger that there's an obligation to deal with the replacement.
oh, and
Yeah,
oh,
but normally that is not really spelled out in law because those are admin law principles. Um, I would caution against putting a time frame in. There can be all sorts of reasons why it can't be done within a certain time. But there is usually a provision that allows, that usually says, even if the board isn't properly constituted, the actions that are taken are still valid. That is a standard provision. And it is to deal with things like where you could have, for instance, you could have 4 people resigning from a 8-member board, and you still have work that has to continue. So we usually have that as a constant provision. I would say leave it to admin law principles. Once there's a resignation, it's understood that the position is now vacant. If it is, though, that you want to say have a trigger where a letter is sent to the particular organization, well, actually, it could be done the other way. The person who is going to resign, if they're from the manufacturing sector, what they should do is copy their resignation letter to whoever nominated them. So that could be a mechanism you put in the law so that at least you know that the nominating authority would be aware of the resignation and would then know that they now have to act. Because remember, you will have, well, for certain people, they will be nominated, it appears. Well, except the executive director, that's what I'm saying.
Member Gill.
Whichever way, Chair, I just want to ensure that there is no gap and that the individuals are replaced. I don't believe for the effectiveness of this board that if one member resigns, for whatever the reason, we can have that absence for too long.
Well,
That's
yes.
my colleague to be saying that, and I agree with the Soldier point, that he wanted at by-election speed, the replacement.
Yes.
And I understand the motivation, which is why up until now there's still a speaker in place.
I think something is tickling him.
I think so too. I agree with you. All right, Ministry. I believe it is accepted that the exclusion of a representative from the the trade union movement is an oversight. We have heard from Solgen in terms of having an attorney at law of a certain amount of years at the bar. So just let me hear from you on that.
Yes, Minister, we'll be guided. And also we have to set out, though, that there are many provisions, because we looked at several legislation with standard provisions we body corporate. We could not try to put all of the provisions in this policy document because that would turn into drafting. So we just highlighted some of the areas. So we wouldn't have covered every area because then we'd basically be drafting to cover all the areas there. So what we present here, there are some standard provisions that normally would also go in there. So when you see the actual redraft, then you'll be able to assess all the provisions. But we are guided by the Board of Management and the proposals there, and we will give effect to same.
Very well.
Mr. Chair.
Yes.
Here.
Oh, yes.
Sorry, I just wanted to underscore Member Brown-Burke's point in terms of a gender representation. I think it is quite pertinent and just. Pardon? Okay. Sorry, I'm kind of caught up in another. Yes, but I just don't want the point to be lost. Thank you.
Very well, Member Longmore. Ministry, I know that we moved swiftly to paragraph 10, and that may have distorted the presentation, but could you just pick up from?
We have been focusing on the Board of Management, so
Yes.
I would like to get to the authority itself, which
Okay,
is what
very
would
well.
have been there.
Mrs. Seeley Brown, Samantha, for you could speak now. Yes. Yes, use your mic.
To draw to the committee's attention before we delve into this matter, that the establishment of this statutory authority is going to change the scheme of the bill, Chair. So it means that we're going to have to restructure and rethink the scheme as to how we set it up. Because this has to come at the beginning where you establish the authority, you give it its functions, and of course we have to look at the functions because these functions will have to change, and its powers and delegation powers and all of that, and how we link it to how you're going to have your labor officers, if you're going to still have them. Well, that's the thing. No, so all of that, so are you going to appoint? Yes.
We have moved away from
yes,
that,
I
yes.
just want us to be clear that it changes the entire scheme of what we're doing here, and we may, after we have looked at this part, have to go back now and look at the other things that we have done before to see how it fits in to the scope of the authority. I just want to just be cautioned that, you know.
Well, I think, Mrs. Seeley Brown, I know the ministry had spent extensive time looking at how this shifting policy would impact the entire scheme of the bill. So I know consideration was given. It was well noted that to a certain extent, this policy change would impact the scheme of the bill. But,
Mr. Chair,
yes.
on that same point, very important. Because even last week, at the last meeting, we were discussing about the training courses and the curriculum, and that technical committee, along with ministry official, helping with the curriculum. But if you have this public body now, which will deal with all the issues under the bill, how does that impact on the training component and the course development and the curriculum development? So it is as if all the things that we agreed on previously, we have in consideration. Because you can't have this authority and then you have another body developing the curriculum for training.
I think the discussions surrounding training referred to the director.
No, but it's
yes.
a director along with the technical team in the ministry.
Yes, no, I think what the ministry has come with today is that the director, having a director with awesome powers, was somewhat problematic, and they are now seeking to insert this authority wherever the reference is made.
Probably yes. I'm in confused now. What will be the role of the authority then? Let's establish. Yes. Is it just a specific role or an overall role the authority will have for the execution of the agreement? So let's be clear.
Yeah. My understanding is an overall authority.
I'm asking questions that I know what the answer should be.
Okay, so I think, Chairman,
yes.
perhaps part of the problem we have,
yes.
and I'm now saying we, because
it impacts all of us.
No, meaning yes. that it appears. So you have been having the discussions with the ministry internally, but nobody else really knows all of that detail. And the thing is, the documents that have been presented don't include all of that detail. So Mrs. Seeley Brown keeps saying some things to me, and I said, well, it's not that these are insurmountable issues, but they need to be clarified. For instance, you already have a division. Remember, this was establishing a division in law, but you actually do have a division in the Ministry of Labor. Who's going to staff the authority? Now, I'm assuming it would mean that some of those same OSH officers would probably go over. They would no longer be civil servants. They would now be employed too. So you have to have what we would consider transition provisions. There's no mention of that. And the transitional arrangements, how you deal with the staff, what happens with the staff, all of those things are things that, again, we suggest you can put in transitional provisions in the law. We have examples of those, but before we can get there, we would have needed to see something, and it's not, doesn't appear, because I mean, I'm just still reading through, but it doesn't appear as if it's captured here. So I think that is part of the issue, that what we have here is just a very, it's almost like part of the framework, but I think everybody is looking now for more of the meat. So you have like the bones, and everybody is wanting to fill out the meat, the flesh, and everything else. And we don't have all of that information before us.
Before you come in, Mrs. Seeley Brown, on the matter of the transitional, Mrs. Bennett Campbell, It is said that it is not included here. Do you have anything to comment on that? Yes.
Well, before I was making an assumption, which really I shouldn't have done. But
Yes.
is it where would the staff come from?
Mhm.
Because
Yes.
you wouldn't need transitional provisions if you're not moving the ministry staff over.
Yes.
If you are moving the ministry staff
Yes.
over, then you need to have provisions to deal with that.
Mhm.
There's a question in my mind, Chair. Are we continuing something that we have in place now by, as Mrs. Aldred is saying, moving them over as employees of the authority, and you have these transitional provisions, with their terms and conditions of employment and all of that, or are we creating an entirely new entity, and who we're going to staff with, technical persons to do it? Well, that's the thing. The other thing I wanted to mention, Chair, with respect to the Board of Management, I'm in agreement with what Mrs. Aldred is suggesting. Sometimes I think if the boards are too big, you hardly get anything done. And what we can look at is having a smaller board, and then you have subcommittees of a board, where the board has the power to appoint subcommittees to do technical things that may be required to be done in accordance with its functions under the Act. So you have the subcommittees who would be answerable to the board, and you have a smaller board who would basically assist with the governance, advising on the governance and the regulatory functions of the authority.
Let me just
Yes.
respond to the last thing Mrs. Seeley Brown
Yes.
suggested.
The matter on subcommittees.
Well, I'm not really going there.
Okay.
You may end up with subcommittees, but in terms of the critical functions of this board, I wouldn't want it to be felt that the role and functions, and you're not saying that, but I just want to make it entirely clear, that the role and functions of the trade union in terms of this is going to be subsumed in any subcommittee.
Yes.
I asked a question earlier on, but sometimes when you ask questions too early, it don't gravitate and generate the type of momentum. So I asked earlier if it's going to be a separate body. But now that we start flesh out the thing, it's clear. And then I ask about what is going to regulate it and how it's going to operate. And now we start hearing about the question of staffing and transitional arrangements. Now, it comes back in my mind that this is a policy direction without the requisite support that is going to go with it, that we need to understand and appreciate. Yeah? So that's what the ministry has come with, a policy direction. But the narratives and the support and all those factors that are supposed to go with it, we need to see it. And I'm glad you opened the door about the impact that it is going to cause on this legislation, because when I saw this, it started to create some gray areas in my mind as to what are some of the things that we would have worked on so hard to establish and to indicate. How are they going to be impacted now, and how difficult it's going to be to go back to some of those and identify them, to ensure that whatever direction that the ministry intends to take, it is in sync with those work that we have done for the past couple of months.
Yes, Member Brown.
As a lawyer, you would be familiar
Yes.
with something that lawyers and the court doesn't like: to be ambushed. And I get the feeling this morning that the committee has been ambushed by this change. We've done a lot of work. Matters will be reported through conciliation. And now I'm hearing about an authority. So the conciliation track, I'm not sure what has happened to it. So we have had other discussions. Thankfully to your honesty, Minister, you said these policies, the ministry is aware of it. You even raised the issue in response to the Solgen of transition clause, which means these things have been discussed inside the ministry, but the committee is unaware of those discussions. There's nothing in the document which says, well, there are more things we discuss, but we wouldn't put it in the document. But at some point down the road, we will raise them. One would have thought that you'd say, this document is not exhaustive. So at least we would have had a hint that there's much more discussion. And it raises the issue for me of the consistency of the bill now that this major intervention has been. And so it is incumbent on the ministry to say to us, this shift in policy means the following for the things we have done so far. And we therefore ask to take a little week to re-engage and to see what consequence, if any, exists for those clauses that we have agreed on. And so that's how I feel, because this is a big turn from where we're going. And so
yes.
maybe the consequences of this need to be shared with the committee. Otherwise, we work in vain.
Very well, Member Brown.
Mr. Chair, just to add.
Yes.
For example, if you look at the proposed amendments, clause on this document here, number 3, clause 133. The amendments here to clause 133 are merely some cosmetic changes, you know. But then, if you have an authority in the bill, page 90, you have functions of the director. But if you have an authority, will it just be a mere transfer of the functions you have here for the director to the authority? Because critical to any policy that you want us to consider to put into a bill for drafting procedure must be what are the functions of this new authority, but we don't have it here today. So even this sheet that is before us, it makes little no sense we consider it, because what are we going to agree to? We're going to agree in a cloud environment. An authority, you know, you see, is not just a simple, the word might sound simple and easy to pronounce, but the authority has huge functions, responsibility, and power. The public body basically operate, quote unquote, on their own. So it's critical. So, and my question, let me, Frank, when have we arrived at this policy shift? We met last week, Thursday. No, I'm clear. Cause I left last week Thursday and I left feeling that, yeah, we were making progress and we're going to move now. And we set out a number of dates for the rest of this month. So it is when? Friday we have this new policy shift? And why were the committee not informed that hold the brakes? There are some new policies coming that is, because it's a fundamental shift, you know.
All right, Member Scaffrey, your point is duly made. Mrs. Benny Campbell, in respect of the impact of this shift on the bill, are you in a position to see at this point the clauses or the parts of the bill that will be impacted?
Well, it does not impact all of the clauses we did before. It impacts a lot of clauses going forward.
Yes.
But that was part of the reason, though, why we were not fighting for the labor officer, because in terms of the role of the labor officer and the provisional improvement notice. But to make the committee be satisfied, we'll be willing to look back and come with all the clauses that we believe will be impacted.
Yes, Mrs. Seeley Brown.
Just want to say to the ministry, though, I think it may impact on the procedure with relation to the procedures that you have in relation to registration and how now you are going to chart this registration procedure through the authority now that you have a board. So I won't say in a wholesale manner that it may not impact what we may have done before, because we have to look again at the registration mechanism, I mean, apart from other things, but the registry, because registration was dealt with earlier, how then is this application going to be made? Is it that the board takes this decision now, or the technical staff in the authority, who would advise the board, things like that. So I don't think, Chair, though we're in a position now to look at it in that way until we establish in our minds how exactly we're setting up this authority and what are the functions we're going to give to the authority and the powers that we're going to give to the board and how we, I think we need to deal with that first before we speak about how it impact the other provisions of the Act.
Well said, Mrs. Celia Brown. So am I hearing you, Mrs. Celia Brown, that before you take your call, that this is a matter that you would be prepared to sit with the ministry, along with the AGC,
yes,
to look at the impact of this policy change on the bill as a whole?
Yeah, but once the ministry has its policy in place as to how we're establishing this authority, yes, sir, most definitely.
It is seeking to treat with the functions under 133. And the functions under 133, if you look at them, they are very expansive in nature because they deal with collection of data, monitoring, deal with education. Now there are aspects of the bill that treats with training that Mr. Mahan made lengthy presentations on. So I just want to be sure in my mind, because once you set up a body corporate, it can be a shell, not doing anything and waiting for work to come in. It must be generating activities. And so we have to ensure that there's also no replication or duplication of functions between this authority and the ministry itself, that people are not confused as to where to go and who has the authority to do certain things. So we have to flesh it out so that it don't appear complex in any way, shape, or form, because of the objectives of this piece of legislation that is going to require a change in behavior. So we have to minimize as greatly as possible the confusions.
Chairman,
Yes, my brother.
I'm sorry that I have to be intervening so much, but I hope my brother Gail would have addressed the fact that the Office of Parliamentary Council has now kindly agreed to meet with Labour to flesh out the policy implication in terms of the draft of the bill. But I'd like to beg that not stop at 133 and the policy thing, but to look at the bill in its entirety. We have been begging for this for a long time. I think, what is clear, and let us say it, there is no divide in this Joint Select Committee amongst parties.
It's not in this bill.
The divide may be on a Friday, as Senator Gale said. But there's no divide among us. We've been working together, almost conspiratorial, if you wish. All right? But we've been working together to make the best bill we can. What the deficiency has been the lack of cooperation. Well, let me withdraw that word. The lack of coordination, or, thank you, Senator Skeffrey, lack of cohesiveness, that's the word I wish to substitute for all, between the legal agencies and the Ministry of Labour. And so if we could get that cohesiveness in the approach to the whole bill, the entire bill, we're going to be able to make progress quicker. And Chairman, what faces the nation now begs for such a bill to be in place strictly such a bill to be able to give us the experience to face the difficulty we face. While I'm sitting here, Chairman, I just want to say this because I think we all need to be concerned. There's a statement which says patient 2 had a child at a particular school. I won't name the school. Well, I'm not going to name the school, but at school X. The child didn't go to school today. Then school X has now, because that is in the paper too, well, it's online. School X has now closed and sent home all the children. And I just sent to my sister, Member Brownberg, all of those children who are now been let off from School X are rushing to buses with workers and other children, and they're all going to go home, and I'm not sure what instructions they have. So their family at home now become potential risk. And I'm saying this now because parliamentarians are not immune. The Minister of Labour in the United Kingdom, the man in Vice President in Iran, and I just saw something that some lady went to. No. Some lady went to Mar-a-Lago and met with a certain person, the Brazilian press secretary. Went to Mar-a-Lago, met with a certain high official who alone can fix it, and she's down with coronavirus. So I make the point that I'm not sure we're properly prepared, no matter how much talk on press conference, because with all those children let off from school today, I hope and I pray, and let me say this about 10 times, I hope and pray that none of them is affected, and that the spread is contained in our country. Even though when I use the word contain, I don't want to sound like Kelly and Conway or those people. But I prayed for our country, that our country will be spared the worst of this. But the best way to escape it is preparation. And this bill will teach us to be prepared for things like this in the future. And that is why I hope the coordination, the cohesiveness can take place so we can address it. So thank you, Chairman.
Yes, Member Cuthbert.
If I may, I sit here each week learning and listening to my colleagues here from their trade unionists. But what I'm picking up really is we come here each week, sometimes twice a week, and I don't see where we're really moving as fast as we should on this bill. I'm wondering, just agreeing with my colleague, if we should just, which I think I'd asked for a couple months ago, if we just need to possibly take a break and have, the ministry really take a look at this bill and redraft, I don't know, do something. And then for us to reconvene and come back and maybe then we can move forward. Because I think what we discussed maybe one point since we've been here since 10 o'clock, and it's now minutes to 12. And we're still talking about the same thing. So I'm not sure how fast we're going to get to the end of this bill if we continue on this path.
Yes, Member Brownberg.
Yes, thank you, Mr. Chairman. To echo the sentiment of Member Cuthbert, I believe that almost every member of this committee at some point or another has made that call, which also tells us something else. But Member Skeffrey asked a question, and then in the response, I think it was Mrs. Bennett Campbell, said that part of the reason why she wasn't pushing for the labor officer, I think it was, in a previous discussion, was because of this consideration. And I'm going to be honest that when I heard that, my spirit just sank. It sank because it means that the discussions we're having need to be a little bit more frank and transparent. If you remember Member Skeffrey's question, he said we were here last meeting. I wasn't at the last meeting. We were here last meeting discussing, and when we ended, he thought that we were making progress and we were going ahead. But based on what was said now by the ministry, obviously even then they were aware of, at the very least, a contemplation, yes, of that policy shift. And I must say to you that in as much as we have really all been working to make progress and to move ahead, in as much as we have often been very uncomfortable, with with what has been before us, but we have really been trying to pull it together so that we can push ahead. It really is very disheartening to hear that comment and the implications of it.
Member Bromberg, there's no doubt that the committee has been doing great work. The difficulties contained in this bill, I believe it is known to every member of the committee, and I'm not seeking to put forward an answer on behalf of the officer from the ministry. What I do note is that the process of the policy adjustment included an approval from the cabinet, and that approval only came on Monday of this week. So I think that may very well have been the reason why it was never communicated before. I do understand what you are saying, but the utterances of the office of the ministry before the approval could have been problematic, as you can imagine. So it is only until now that firmly and definitively the ministry is in a position to say anything else would have been in hope and premature.
Mr. Chairman, I hope that we understand that we should really privilege substance over form. And if that is so, then, and you are in a position, you are unable to say anything, because I wasn't asking for an admission of all that was being done. A simple, let's look at that a little bit more, or, let's think about something would have been sufficient. And if you are still not in a position to do that, then take a break. Sufficient to get us to that point without having us go through that discussion. And honestly, I would be negligent if I pretended that it's okay.
That's another question.
Yes.
Are there any other policy changes to come with respect to any other parts of this bill that, if you have not yet decided, at least can caution us? Because what I don't want, and I'm clear, it doesn't make, we come here and we can deliberate, but it doesn't make sense when we agree. You agree on policy A, and there's a shift from A to B, then it must have implications for what we agreed on. So I would want to know, not in details, because I understand policy has to come from one authority, and I respect that authority. But at least the minister, through you, Chair, to say, for other parts, we are contemplating shift in AB, so we'll not,
give us some time.
and it will have implication for what we had agreed on.
Yeah.
What is happening? What is happening is as if we are in a circle.
What I will say, Member Skeffrey, is that it is not foreseen that there is any other serious policy shift in respect of this bit of legislation. As you are aware, the discussions that we have from time to time and the light that is being shed on the different clauses may involve some policy considerations. But insofar as the ministry can foresee there is no other policy shift to come in respect of this bill.
Chairman, all you have said so far before that have given me comfort. What you just said a while ago hasn't given me any comfort. I'll tell you why. This committee has been very collegial in our approach. The issue of cabinet intervention only came up because I asked if the cabinet had approved. And I had not been busybody. Yeah, just been busybody.
But you raised it last week, member. I don't know if you recall that. You raised the point last week about advancing the bill, and I gave you a certain response.
Well, I can't even recall that response, but suffice it to say, suffice it to say, suffice it to say, sometimes busybody can be a very good thing. And others who want the information not to be known. So I raise the issue, Chair, because we've worked very good. And there's a practice sometimes I don't like, which says, some minister says, under successive government, I am going to take this to cabinet on Monday. I don't necessarily like it because cabinet must, but at least we could have gotten something which said there may be some policy change, and we are going to go through a certain process, and we will get back to you. So don't be surprised if in another week or two, so that we at least will be prepared for it. No, I don't know what else is going to come up that is going to be sudden, that's going to be unprepared. And I'm going to say this because on some issues, like this one, we are united across the divide. I sat at home last week and I watched the Standing Finance Committee. And I was critical of both sides. Critical of the Minister of Finance in not opening up with Corona. Critical of my side for not using the Corona question as the first question, rather than a technical thing about the debt level. Because that is the key issue facing us. And I was dissatisfied that it took the minister 2 hours and 40 minutes of his 3.5-hour speech to mention Corona. So the question for me is, are we attuned to the issues, whether in this bill or the other issues, to see it as a priority? It's amazing. All the pretty announcements have been killed by the Corona. Every newscast I open, I listen to. Corona, 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 Corona. Huh? That's the only thing I'm hearing. So when something like this goes to the cabinet and come back, and we're not even told in the document that it went to cabinet therefore approved this shift, we wouldn't know. But for my busybody asking the question, and so if I'm not given the information, I'm beginning to wonder what else have I not been told. And that worry me, because up until now, I have approached this thing in trusting everything that has been said. I just have a little difficulty when I have to find out. I have something I tell to people, you know. I burst information, I give out information. If somebody tells me something in confidence, I treat it and hold it in confidence. But if I find out on my own, I promise nobody confidence in what I find out.
I have heard you, Member Brown, particularly in respect of your last point. But what I want to say is that at all times there has been good faith in the ministry's conduct. I hear you that the document in and of itself could have been more comprehensive in speaking to the approvals and the points of the bill that would have been impacted by this policy shift. But Member Brown, and I hear you again, I must add that in terms of how it was communicated, hindsight now says that it may have been said, or it could have been said that, a certain consideration is being given and the process is running its course. But I know that the ministry, and Member Brown, I don't know how familiar you are with the process of cabinet approval, but it goes through a number of stages, and comments are usually sought from different departments. So I know for the members of the committee, today would have been the very first time some of you would have, or all of you would have been hearing of this shift in the policy, but there was a series of work and approval from finance in respect of the establishment of this new entity, and thereafter comments from AGC, and then cabinet approval would come, and that is why we are at this point. But what I will, yes.
And this is how I treat
Yes.
consultation, especially against the background that one would be seeking to change something, and that change is going to create an impact. And I always appreciate, this is what I said to employers, if you're going to create a change that is going to create a great impact, then from the genetic stage, advise me. So there would have been some stages taking place leading up to a cabinet approval. Nothing is wrong. Nothing would have been wrong to say to the committee that there is the possibility of a major shift in treating with how we apply (133) and beyond.
Bear in mind that what the ministry is saying, that the, of course, OCPC may share a different view. What the ministry is saying is that this shift in policy impacts future clauses.
Yeah, man. But what I'm saying, Chair, is that we are working through this. And maybe if we had known, because one of the things that I have recognized in terms of this particular committee on both sides is that we pick up things quickly and we work at them assiduously once we pick them up. So I'm just suggesting that it would have been better if there was a signal of some sort that we intend to go this direction, and then we know that we can even prepare in our minds as to how we approach the legislation. The thing is that it's not lost, because we have been down this road before in terms of going through this legislation and recognize that as the debate progresses, we have to make some policy shifts. The question is just how now there's a level of cohesiveness between all parties so that we can get back onto a particular trajectory which would take us in meeting the objectives of this piece of legislation.
Member Gale, what I will say is that at all times, the posture and conduct of the ministry has been one of good faith. And I will accept that just looking at it now, it would have been proper if some indication was given to the committee that this policy shift is being contemplated. I'm not seeking to put forward a reason, but I know that the ministry is saying that the clauses so impacted are future clauses. But be that as it may, I think what is more important for this committee is a meeting of the different teams to see how the shift in policy will impact the overall legislation. So, what is being considered, Member Gale and other members of the committee, is that we use some time for the different teams to meet to consider the effect of this policy change on the overall legislation. And I am suggesting that the remainder of this month be given to the ministry and the different teams for them to meet, and we will pick up on the first Monday of April to resume our consideration of the bill. I must also state again that from the ministry's perspective, it is not considered that there will be any serious and heavily material policy shift going forward. But of course, you recognize as the deliberations ensue, then there may be some adjustments to the policy. So I hear from you, members.
Here you're saying 14 days quarantine, or else more than 14 days for the committee.
Yes.
But sadly, the technocrats won't be isolated. They'll be
self-quarantine.
Huddled masses.
Yes.
Right? But, yeah. It makes sense. It makes sense.
Yes. Yes. So, members, based on the calendar, what it is saying is that we resume on the 6th of April.
I will then inform the JGRA and whoever else wants to come on the
Yes, certainly. We will advise them. Just first, we'll ascertain whether they are, how ready they are in terms of appearing before the committee, and then we will try to give them a date for the appearance, which we will communicate with you.
Would you want them on the 6th?
No, not on the 6th. So, members, do we have any other business? There be no other business. Yes.
Just, Chairman, I hear that your ministry has called a 2 o'clock meeting of the LAC, and I suspect it is to address the corona thing. I don't think I'll be there, but may I recommend that the holiday, that we find a way of quickly amending the holiday with pay act to allow for more than 14 days sick leave in the case of persons contracting the coronavirus. Because we don't want to extend it for everybody, but people may be affected, and that is with pay, because I appreciate the notice from the ministry using moral suasion to the employers to give more than the allotment in the current holiday with pay act for corona. But it may be necessary, and I urge this for those who may attend the meeting with the minister later, to quickly make an amendment limited to the corona period and to extend the sick leave. Because if we ask people to be isolated and they're not getting pay, they're going to die. And because they don't want to die, they may come out. So if we're going to ask them to make that sacrifice on behalf of the rest of us, then we should be willing to give them some extra, some payment beyond the sick leave period. Not to be abused, but to be used where necessary. And I urge that later on. A simple amendment, quick, yeah.
Yes.
There's a particular institution that I have interfaced with by representation that members have been instructed to be isolated, and once that employer know very well that the period is with pay, and it's over and above that stipulated by law, given the instructions of COVID-19, you will have some employers who might not be benevolent in that nature. And so we have to instruct them accordingly. And these are some of the things that, that those guidelines are going to have to be recommended. Because it's very, very important as we all take precautions.
And I'm sure, Member Gill and Brown, that your different groupings will be represented at this meeting, and the points you're raising now will come up then for discussion. But of course, you can appreciate that, the amendment of the legislation, it involves widespread consultation.
I agree with you, and I know we are going, but if you, with your permission, Mr. Chair, the truth is that if we look across the world where they have been able to contain in any real sense, self-quarantine comes with some kind of payment or benefit or incentive for persons to actually go into isolation as one of the ways of containing.
Duly noted. Yes.
Have it in your mind that when you spoke about it requires wider consultation.
Yes.
The construct of the committee that is going to be meeting.
That's the point.
That's it.
That's the point. Yes. That's the point. Yes.
Chair.
Yes.
Just following up in terms of with the recommendations, the extended sick leave and self-quarantine, etc., to ensure that it would be medically verified. It's not just a person relating that, X, Y, and Z is a position, because there is a propensity for abuse of the situation, and the persons who may really need the benefit may not get such because of said abuse.
Yes, duly noted, Member Longmore. May we now have the motion for adjournment? So move, Member Brownberg, seconded by Member Skeffrey. This meeting is now adjourned.
Thank you.